Do you have a power of attorney in place to protect not only you, but your loved ones? Oh, wait a minute. You're not even sure what a power of attorney is or what it's used for? Perfect. This is exactly the FYI you need to pay attention to. So stay tuned. Hey, good morning, everyone, and welcome to Scan FYI. First of all, I just want to say thank you to our sponsor for today's video. That's Garden Savings Federal Credit Union. They are today's sponsor. All right, today we're talking about a very important topic, and that's the power of attorney. And my guest today is attorney Chris Olszak. And good morning, Chris.
Good morning.
So why don't you introduce yourself, much more extensively than I did, and tell the folks a little bit about you.
Great, thank you. So my name is Chris Olszak. I'm a certified elder law attorney, and I'm with the firm Davison, Eastman, Muñoz, Paone, and Respond Law, as you can see behind me. So I'm a certified elder law attorney by the ABA-approved National Elder Law Foundation. And that means my practice is really geared toward retirees or seniors and the legal challenges that face clients that maybe have retired and maybe they have financial issues, or maybe they have issues associated with aging, such as needing health care, but also a lot of basic documents like estate planning documents, wills, power of attorneys, and advance directives, which are medical power of attorneys. And I'll talk a little bit more about that as we get into it. I've been practicing 21 years now, and primarily my clientele is in Ocean and Monmouth County, and we have offices in Freehold and Toms River.
All right, and for those of you listening, we'll have all of Chris's contact information, everything you need to know to reach out to Respond Law. We'll put everything in the description, so you'll have no trouble reaching out to Chris. So first of all, I think the number one question is, what is a power of attorney?
So power of attorney is a document that somebody executes. The person that executes the document is referred to as the principal. And the principal designates somebody referenced either as an agent or attorney in fact to handle certain aspects of the principal's life. There's generally two types of power of attorneys. One is for financial purposes, and the other is for medical purposes. And they may take different names. But generally, in what I do, I'm concerned about having what's called a durable power of attorney. And for my clients, what I'm concerned about is later in life or at some point, they may become disabled. And I want the principal, when they're competent, to designate somebody to act on their behalf if they're no longer competent to manage their own affairs. And it could be as a result of many things. I mean, it could be that there's a car accident and the principal is injured and in the hospital for a period of time and simply needs somebody to pay bills. It could be a situation where health concerns come into play, whether it's dementia, maybe there's a stroke, and it's going to be something that after that health concern, the individual needs assistance for the rest of his or her life. So a durable power of attorney is durable if it indicates that it is still effective when somebody becomes disabled, which is generally in what I'm doing, we want it to be effective after somebody's disabled. And also that it doesn't, the power given to the agent or attorney in fact doesn't lapse by a certain period of time. So we want it to be there indefinitely if somebody's become disabled. And I'll give you a different example of some power of attorneys that we might not want to be permanent. I've done real estate in my career as well too, and maybe a client is moving and they want me to sign some closing documents. Well, they can authorize me under a limited power of attorney to sign closing documents, but they're not going to give me, they won't give me access to their bank accounts, and they just want it limited to that particular time frame. But in general, for most of my clients, I'm recommending durable power of attorneys that allows somebody to handle everything on their behalf. So it's paying bills, filing tax returns, maybe selling real estate, maybe handling lawsuits. If there's a car accident, and unfortunately, I've had clients hit by drunk drivers, where then the power of attorney may have to institute a lawsuit against the other driver. So having a good comprehensive power of attorney allows for somebody to step in and help when you become disabled. And many people may be saying, well, I'm healthy now. Why do I need this now? Why can't I wait until later? And the answer is, well, if there's a disability, I don't know in the future that you would be competent to sign a power of attorney. So you really have to do it while you're healthy.
Oh, all right. Well, that's an important thing to remember. You want to be doing this while you're competent. But, you know, also, Chris, as I'm listening to you, I'm realizing, so I know a lot of people are thinking, well, this is something for when you're older. But, you know, you could be 35 years old and have a whole family and be temporarily or even permanently disabled, and you would still need a power of attorney to have, you would need those same protections. So for people listening, even though I understand that, you know, you're more of an elder law attorney, but I want people to realize the importance of a power of attorney at any stage in your life. So that I just want to make that clear.
Well, that's a good point. And yes, everybody once they're 18 should have these documents. And I'll give you a little bit different explanation, which, you know, when you think about it, it probably makes sense. But parents that have children going off to college, 18-year-olds that are in college, they're now adults. And right. if that child gets sick and is in the hospital, technically the parent doesn't have any authority once the child's 18. So children going to college, they should have power of attorneys. And although it's focusing on the financial aspect of it, the medical power of attorney, you may have heard of it also referred to as advanced directives or living wills. Those are power of attorneys for medical decisions. And it's the same thing. That document allows a principal to designate somebody to speak with a doctor and make medical decisions. And it does apply to everybody of all ages. So for instance, if there's a college age child that gets sick and is in the hospital, a parent can't call up the hospital and say, well, my child is there. I want to know what's going on. Unfortunately, once the child's 18, they're an adult. And unless there's a HIPAA waiver or a power of attorney in place, the hospital doesn't have to talk to a parent. And it could be the same with spouses. I mean, sometimes spouses at the second marriage, you know, or it's a long-term relationship where they're not married. Let's say it's a boyfriend-girlfriend situation. They live together as though they're husband and wife. Under the eyes of the law, they're not married. So if one partner goes into the hospital doesn't have to speak with the long-term partner, and there may be restrictions on access. And that's the idea of the medical power of attorney. Also allows somebody to speak with your doctors or gain access to your medical records. Again, if you're not competent to do so.
Well,
so
I see that there's a lot more to this than I think most people even think about. So you just gave really an excellent explanation of what it is. And then the point of it is, if you don't have it in place, and let's say, you know, you are 75 years old or 55 for that matter, and something does happen and you don't have a power of attorney in place, let's say you're married. So as your spouse, can I just go in there and do what I need to do without having a power of attorney in place?
So that's an excellent question. And the answer is no. You know, for
so
medical
as a
decisions,
spouse, I don't even have any rights at this point.
Well, you do have rights, but as a spouse, you're not automatically entitled to do something on behalf of a disabled spouse. And so I'll give a few examples. One is a house. Let's say husband and wife own a house together, and the husband gets sick and there's no power of attorney in place. Well, if the wife needs to sell the house, she can't just sign her husband's name to sell the house. If there's no power of attorney in place and the husband is no longer competent to sign a document or sign a deed to sell the house, then potentially a court action called a guardianship has to be in place, so that a guardianship is a court action to give authority over somebody who no longer has capacity but doesn't have a power of attorney in place. So even as a spouse, you just can't sign another spouse's name on tax returns, real estate transactions, or if the spouse, let's say, has a retirement plan, pension plan, or IRA separately in that spouse's name, that's the spouse's asset. For instance, I have a retirement plan. My wife just can't call up and say, I need to know what's in there. She has to have my authority to do so. And when there's a disability, that's the idea of the power of attorney, to designate even a spouse to get access to funds. And just because you're married, unfortunately, these days, that doesn't mean anything.
All right. Well, I think that's important to know, because I feel like a lot of people are under obviously the misconception now that just being the legal spouse gives you the authority to, make some of these choices. But if that's not the case, that's a huge reason to make sure you have a power of attorney in place. Now, I know a lot of people would say, well, all right, I could just go online and, and I know you could just go online and do all of this. And so, Chris, what's your feeling about that?
Well, so there are forms. You probably go to the stores and buy forms as well, too. What you're not getting there is legal advice for your particular situation. And you may not be filling these forms out correctly. So, for instance, I have seen power of attorneys where somebody has signed the power of attorney, but sometimes the forms online or the forms in the store have checkoffs where certain provisions are supposed to be checked off, and the power of attorney is just signed and nothing is checked off. So technically, the person may have signed a power of attorney, but they may not have really authorized the person to do something. And it may not authorize the person to do what's needed in the particular situation. So, for instance, sale of a house. If that authority is not in that document and the person needs the house sold with the power of attorney, if it's not in that power of attorney, that authority is not given. So,
Makes sense.
Yes, you can get these online, but you may not be getting the best document for your needs. The other situation I've seen happen where people get these, they don't put backup agents named in the document. So I haven't really, but my preference is when somebody does a power of attorney or a medical power of attorney, you have one agent named, but I want a series of agents named, because your agent could also be disabled before
Right, that's
pass away
true.
before
That's
you.
true.
And that document then is no longer effective if there's no other backups. And sometimes that's the hardest thing people to decide on. Maybe they have multiple children, but it's not always that the oldest one is the most responsible, or maybe the children are disabled and they really can't help out. So having backups is a good idea, but I find with the ones online or store-based, yes, they might work, but they're generally not the best documents you can get. And I should say, getting these documents done should be reasonable. I mean, even if it's with an attorney, these generally are not expensive to get. And getting them from an attorney, I think you'll be better off if you need to use these documents in the long run. Because if you save money up front by getting them online or at a store, and then we miss something and the documents can't be updated, then we may have to go through the court proceedings of a guardianship, which is expensive, time consuming. And let's say you have multiple children fighting or multiple family members fighting, it could be drastically expensive.
I mean, I think for me, a lesson that I learned, because as I said to you earlier, I had recently done this for myself and I did use an attorney. And I do have some friends who had done this online. And of course, when you see an attorney, you're face to face with a person who's asking you a lot of questions that were not necessarily even be on the form. And they're making you think about your own unique circumstances because, well, right, everyone is different. And I wouldn't know, as I don't know the questions to ask myself. I'm not the attorney. So I think it's well worth taking the time, and it isn't a huge expense. It's worth it in the long run to really see an attorney to make sure it's done right the first time.
And I would say, in terms of documents that I do wills, power of attorney, medical directives, and trusts. If people pass away without a will, New Jersey still has a plan in place for how assets pass. It's not that the state comes in and take your money, but with a power of attorney, in my opinion, that might be more important than a will, because there really is no plan where it says, well, a spouse can step in and your child. It's that if you have capacity, you can do it. If not, you go to court and do a guardianship. And then you're leaving it up potentially to a judge to make a decision about who should be in charge of your life. So, I think the power of attorney is probably more important in many situations than even the will.
All right,
Somebody
that's
passes away
good,
without a
good to
will
hear you say that. Yeah. But
because
now,
I'm sorry.
no, that's all right. A very important question, because we have a power of attorney, my husband and I, let's say, and I have to invoke it or execute it. I don't know what the right word is. What's to stop me? What is the safeguard in place to stop me from taking our assets and just sort of moving them into another area, like all in my own name, or basically, stealing? What is there a safeguard in place so that doesn't happen?
Well, there are potentially. With husband and wife, if you jointly own assets anyway, transferring between spouses is not necessarily stealing. However, a power of attorney in New Jersey does have to authorize gifts to be made from the principal to other people. So, for instance, just by signing a power of attorney, if your husband designated you as his attorney, in fact, that doesn't automatically authorize you to take assets out of his name and transfer it to yourself. New Jersey's power of attorney laws specifically say if somebody wants you to have the authority to make gifts, it has to be in that power of attorney. So a better example with husband and wife, that might be a different story. But let's say it's a child is named as the power of attorney. If that power of attorney doesn't authorize gifting, yes, the child taking money from the parent out of the parent's name and transferring to themselves could be looked as improper under the under power of attorney. It could be a breach of fiduciary duty to the parent. In certain circumstances, it could be theft. It depends on the situation. And a better example is I've seen some people name financial advisors or accountants or even attorneys as power of attorney. And unfortunately, people have been stolen from. So the document does grant wide authority. And part of it is that people do want to designate somebody that is responsible. So with the power of attorney, if you have concerns about the people that you're designating, you may not want to designate them. You may want to designate two people together so that there are people that can watch each other. Granted, they can both agree to take your money. Banks do try and screen for some of this stuff. There's Adult Protective Services, a county, part of the county. Ocean County has Adult Protective Services. Monmouth County has Adult Protective Services. So banks can report fraud to Adult Protective Services. And so, power of attorney is not a license to steal. But it does depend on the situation, because people, in my discussions with clients, I may talk to clients or I do talk to clients and say, would you like, under certain circumstances, gifts to be made from your assets, potentially to the person that's in charge of your finances? And so it may not be theft. It may be part of the overall planning that we discuss and do, because right now in New Jersey, we don't need as much estate tax planning from parent to child or parent to grandchildren. Currently, there's no estate taxes, and between spouses, there's no estate taxes. But up until 2018, there were. So gifting did help out with estate taxes. So there are purposes behind that, but there could also be theft, unfortunately, and there sometimes it's the other children or other family members that, if they see this happening, maybe they're getting involved and taking the child that has power of attorney to court and asking for what's called an accounting. So there are potentially safety measures, but for unmarried people with no children, sometimes that's harder to find who the appropriate person is. And I discuss that with my clients, but ultimately you want to designate somebody that's responsible to handle these affairs. I get into clients also, do children have gambling problems? Do they have drug or alcohol problems?
Right.
If they do, those are probably not people you want to be in charge of your finances.
So you really do have to think long and hard who you are going to give this power of attorney to. And, and there again, I'll say, as, someone who's recently done it, all the more reason to have a good conversation with your attorney, because I think speaking directly with someone like you, Chris, you're going to bring up ideas that somebody might not have thought about, who is appropriate, who's not appropriate. So I think that's, if you have a child who's got an addiction problem, probably not the best person. You have to think long and hard who you are relinquishing this power to, right?
Yes. And
very important.
The good thing is that I'm sure you've heard of attorney-client privilege. What we talk about is privileged. And the benefit is that I think people can be honest with me. And if they're honest with me, I can advise them properly. And that's one good thing about meeting with an attorney. You will get other ideas, but what you talk about stays confidential. And you may not be comfortable talking to your multiple children about the concerns you have about one over the other, because that might make it's just uncomfortable. So, and my goal is to get the best document to allow somebody to help my client if they're disabled. I mean, that's really what it comes down to. And that's the way these should be looked at. If my client is in a situation where they can no longer help themselves for financial purposes or medical purposes, they need these documents in place to allow somebody to make decisions on their behalf.
All right. Well, Chris, I really appreciate all your wisdom today. And I hope that everyone listening will really take this to heart and make the right decision for themselves to make sure that you do have a durable power of attorney in place. So just trying to think. Yeah, I think we covered everything beautifully. I want to say that all of Chris's contact info will be in the comments. And I want to thank once again our sponsor for today's video. That's Garden Savings Federal Credit Union. All right, Chris from Respond Law, thank you so much for being my guest today.
Thank you for having me this morning. It was fun.
Okay. And remember out there, if it's important to you, it's important to us. I'm Andrea Tarr, and we'll see you next time on Scan FYI. Bye, everyone, and bye, Chris.
Bye-bye.